speech is all about. And that doesn't make it, that does not make it subject to regulation or prohibition. And I quote, "The claim that the expressive expressions were intended to exercise a coercive impact on the respondent does not remove them from the reach of the First Amendment." So even if in this case the defendant's speech was intended to coercively persuade the parking enforcement officers to leave their employment, it is nevertheless clear that that speech is constitutionally protected and cannot be prohibited under state tort law. Now, there are a couple of other aspects of the Claiborne case that are also pertinent here. Beyond recognizing the right to persuade, even if it meant persuading somebody to breach a contractual or prospective contractual relationship, they also, there's the only exception the court recognized, sole exception, was for violence and threats of violence. And even in that case there were, I think, either 10 or 12 documented cases of violence, some of them involving shootings. And the court said even in that case, we can't attribute the violence to all the demonstrators. And we can't blame the participants for acts of violence that may have been perpetrated by individual demonstrators. But in any event, in this case, there's no significant claim of violence. We don't have to get to that issue of attribution. But the fundamental fact is that persuasive speech, speech that is intended to and has the effect of causing somebody to breach a contractual or prospective contractual relationship, is protected constitutionally, absolutely, and cannot be prescribed based on a tort theory. And one other thing the court said that I think is relevant here is the right of free speech cannot be denied by drawing from a trivial, rough instinct or a moment of animal exuberance the conclusion that otherwise peaceful picketing has the taint of, I'm sorry, well, I lost the last part. But anyway, the point was that even if there had been, you can't take an isolated incident or even an isolated insult and paint the whole demonstration with that. Now, and I guess the other, again, the point that the court really focuses on Claiborne is the importance of the fact that this was an organized activity, and that was part of the right of free association. The court said one of the foundations of free society is the right of individuals to combine with other persons in pursuit of a common goal by lawful means. Now, I'm not going to claim here that Robin Hooding is the moral equivalent of fighting for racial justice. But in front of courts, under the Constitution, all political causes are entitled to equal weight. And the principles that apply in Claiborne, which was a unanimous decision of the Supreme Court, are absolutely applicable and dispositive in this case. Now, in the context of those constitutional principles, I just want to address the arguments that the city's made in response to that. First, they talked about the stress on the parking enforcement officers to the extent of there being a hostile work environment. And again, there's a lot of basis for arguing about what a hostile work environment means, much less whether it existed here. But I don't think there can be any dispute that it was stressful for the parking enforcement officers to have citizens videotaping them, to have citizens plugging meters, etc. But the fact is that stress on government employees is not a sufficient basis for abridging constitutional rights. More centrally, the exercise of constitutional rights, and in particular the right of free speech, inevitably causes stress and pain, sometimes far greater pain than anything asserted in this case. In the Glick case, again, the First Circuit case involving videotaping, where the police department was complaining about how they would be affected if the people were allowed to videotape them, the court said In our society, police officers are expected to endure significant burdens caused by citizens' exercise of the First Amendment rights. The same restraint demanded of law enforcement officers in the face of provocative and challenging speech must be expected when they are merely the subject of videotaping that memorializes without impairing their work in public spaces. Now, although the Glick case would specifically involve police officers, there's no doctrine that would justify separating or treating one category of public employee any differently than the other. Another, and again, I think recent aspect of this point is the case of Snyder v. Phelps, which is a 2011 U.S. Supreme Court case. And that was a suit brought by a father of a soldier who died in Iraq. And when the when the soldier's funeral was held, these demonstrators from this church in the Midwest who believed that basically soldiers died because this country tolerates homosexuality picketed the funeral with signs saying, thank God for IEDs, thank God for dead soldiers, God hate fags, etc., etc. Now, predictably, that caused the grieving father of the dead soldier, extreme distress. And in fact, when he brought it to court claiming for intentional infliction of emotional distress, the jury awarded him $2.9 million in compensatory damages, which I think is a measure of how much he suffered. Nevertheless, the court said in a free society, speech, even though the speech causes pain, grief, and sorrow, must be permitted. In particular, Chief Justice Roberts noted that speech can inflict great pain. But in the public debate, we must tolerate insulting and even outrageous speech in order to provide adequate breathing space to the freedoms protected by the First Amendment. Now, the city argues that, again, there's this idea of a hostile work environment. And I think the evidence here is far short of a hostile work environment. But the more important legal point, Your Honor, is that notwithstanding the city's assertions, a hostile work environment is not illegal. The city cites the case of Michael Porter versus the City of Manchester, which is a case in which I represent the plaintiff. Porter does not hold that a hostile work environment is illegal. What the court held was that a hostile work environment tantamount to constructive termination. But constructive termination is not illegal unless it's tied to an illegal motive. In Porter's case, the claim was that he was being retaliated against for blowing whistle on public policy issues. But the fact that there's a hostile work environment itself, again, unless it's connected to an illegal motive, is not illegal. So the city's constant invocation of that term has no meaning at all in terms of creating any legal imperative upon it to take action in this case. Again, even if a hostile work environment were illegal, it would still be trumped by constitutional considerations, but that's not enacted in state law. Now, the city also complains about safety issues. And again, there's discussion about, well, we're distracted and we do this or that. We've got 2.5 days of testimony. There's no significant testimony about any safety problem. Beyond that, except again for the assaults on demonstrators, I'll mention in a minute, but beyond that, we're talking about downtown Keene. We're talking about, if the city had legitimate safety concerns, they've got a whole police department in that area. There are many other ways to address the safety problem beyond restrictions on demonstrations. Now, the League New Hampshire case, and I'll provide the court with the name of my memo, but it's a 1970s case in which the group of Seabrook demonstrators were demonstrating on a traffic island in Seabrook or Hampton. And they were arrested, and basically the town said these people, getting all these people on traffic island, busy traffic, look at all the safety problems we have. And the court came back and said that if there really is a safety problem here, the city has an affirmative duty to protect the safety of demonstrators, not suppress the demonstration, or for that matter, restrict the demonstration. In terms of the claim of that this is a distraction, well, perhaps it is, but surely parking enforcement officers should be trained and are trained to deal with distraction. One of the facts in this case is, despite all the complaints about the Robin Hooding activity, which has now gone on for 5 years, there's been no evidence that the city has provided any type of training or protocol to its employees, which is inconsistent with the argument that it somehow has prevented them from carrying out their duties. The only significant safety issue that came up in this whole case was the 3 assaults committed on the defendants. And again, that was evidence brought up by the city as if it somehow supported its position, when in fact that evidence has the opposite effect. It shouldn't take a lot of argument to establish that you can't have people limiting or suppressing demonstrations because they're by assaulting demonstrators. And what sort of precedent would that be if the city could limit rights of demonstrators because these people would be subject to assault by other private citizens? That's a classic example of the heckler's veto. And it just, first of all, it permits the grounding out of speech based on lawless activity. But the other part of it is it permits those relatively small handful of people who choose to engage in illegal activity to drown out all the many people who have provided, peaceful feedback, both positive and negative, to the demonstrators. So it can't possibly justify any type of injunctive relief that the city is asking for. Now, that finally comes to really what the city's fundamental argument against the constitutional claims. And that argument is that all they're asking for is reasonable time and space, well, the time, space, and place restrictions, but they're not really asking for time restrictions or place. They're really asking for space restrictions. Now, first of all, they justify these restrictions based upon the theory that the proposal they're making is content neutral. And I think it should be clear from the 2.5 days of hearing this case that that's just not true. That this is not a content neutral proposal that's intended to apply to all demonstrators. It applies to, it's limited to one specific group of demonstrators. And it's not in any way, I think it's clear that if my clients were there just telling parking enforcement officers what a great job they were doing, none of this would have occurred. So clearly it's addressed at a particular type of communication by a limited number of people. And if there were any question at all about that, if there was a shadow of a doubt, then the nature of the relief here makes that absolutely clear. In other words, they're not asking the court to issue a general order applicable to all people. They're asking specifically that 6 people, and 6 people alone, be enjoined. And again, I'll cite later to get into the relief issue, but I mean, the Supreme Court has said on its face, the U.S. Supreme Court, that is conclusive proof that this is not a neutral, it's not a neutral action, and therefore the time and place, time and manner restrictions are not applicable. And that, again, I'll cite the memo, but that specifically in the Madsen v. Health Center case, the U.S. Supreme Court said that you can't apply that standard, which is the lack of neutrality, when you're asking for an injunction as opposed to enforcing the existing ordinance. Now, in terms of the space issue itself, again, there are 3 different activities here, and space considerations for each activity is different. And at some points during this testimony, the plaintiff's counsel has tended to try to merge them together, which terms of the Robin Hooding activity, we were told that the 10 or 15 feet was an optimal space, but that there would inevitably be times, many times, when they were closer to parking enforcement officers, not necessarily because they went to the parking enforcement officers, but because the parking enforcement officers would come up to them to go to the meters or to the crosswalk, etc. Now, on the videotape, again, certainly nobody's claiming here that there's a right to stick somebody's videotape camera in somebody's face. But there's been no evidence in this case that that's ever happened. And in the Glick case, which remarkably, defense counsel said was I guess, those of us on the civil liberties side of things, at least has been a sort of a case, a strong civil liberties case, the defense counsel came up and said, well, it's a time, place, and manner case. It was an interesting interpretation. But in the facts in the Glick case, the guy doing the recording was 10 feet away. And the court said in that case that 10 feet is well within what's permitted. So the court didn't say how close you could get. It didn't say whether it was 2 feet, 4 feet, 6 feet. But clearly, the court made it clear that the permissible limit was something under 10 feet. Certainly nothing, any family resemblance to the 30 feet